Hello there everyone, today's video is all about a recent VAT case, a VAT tribunal heard in the courts, which actually has a bit of deja vu about it. So let me rewind 30 years to one of what's probably the most famous VAT court case in the land, if there can be such a thing, and it was with regards to Jaffa Cakes. I don't know if anyone out there remembers this. Is a Jaffa cake a cake, or is it a confectionery? Is it a chocolate biscuit? That was the big VAT dilemma 30 years ago, and it went right up through the courts, and ultimately the answer was Jaffa Cakes are cakes. They are not confectionery, because there's a big difference from a VAT point of view. If it's a cake, it's 0 rated, so no VAT on the sales price, as with a lot of foodstuffs. But if it is confectionery, then VAT is added at the standard rate. So the reason I got the deja vu is because this particular case hinges on exactly the same thing. Is it a cake? Is it confectionery? Specifically Morrison's supermarkets, their own branded bars, cereal bars, energy bars, call them what you will, but they have these bars called Naked bars, N-A-K-D, Naked bars. There was a brand. There was about 18 of these different bars, 18 different flavours, and for years Morrison's treated them as if they were confectionery and added output VAT at 20%, but then actually claimed to HMRC that they'd incorrectly charged this output VAT and try to get a refund, which, of about £1 million, £1 million refund they try to claim, to say, you know what, these bars that we sell, these Naked bars, are not confectionery, they are cakes. So the whole thing went to the courts, and decision just been released, and basically I'll just talk you through some of the details of what they discussed at the tribunal. So interesting, they looked at the sugar content of these bars that Morrison's was selling, ranged from the sugar content from about 33% to just over 50%. By way of comparison, Kit Kats are 51% sugar, Maltesers 52% sugar, and your average Mars bars 59% sugar. Okay. Now they also said, look, none of the different types of bar shared any ingredients with the majority of cakes. So the judges even did taste tests, and the judge tested the blueberry muffin bar and said that doesn't taste like blueberries. Not surprising, there was only 2% of the total ingredients were actually blueberries. The bar had no physical resemblance to its namesake, to a blueberry muffin, and it did not taste like a blueberry muffin. And then the judge taste tested some more and said, okay, I can taste ginger in the gingerbread bar and lemon in the lemon drizzle bar, but neither of these cakes has the same texture to their namesakes. So they looked at all these things, the taste, the texture, the sugar content, the ingredients, and basically the tribunal said these bars that Morrison's was selling do not look like most cakes. They are not held out for sale as cakes, and they would look out of place in the cake section in the supermarket. They're not called cakes, but bars. They're sweet to taste. They're eaten with the fingers and are sold and marketed as snacks. So the decision was that these types of bars were cakes and were confectionery and not cakes, and therefore standard rate VAT was applicable. So Morrison's had already a count of output VAT at the standard rate on these. they try to change their mind and say, look, we should be due a refund because they should be Tret zero rated as cakes. And the tribunal said, no, they are not cakes, even though you've got a bar called blueberry muffin. It's nothing like a blueberry muffin, so you're not getting your VAT back on that. So just an interesting recent decision doing the rounds in the news wires this week in the world of VAT, which reminded me to one of the first VAT cases that I learnt about many decades ago, the Jaffa Cake case. Very similar. Is it a cake or is it confectionery? And in this particular case, the Morrison's bars were confectionery. So if you like this video, please do subscribe right there, and I will see you soon.